reading some of our U.S. Supreme Court decisions. And over time, I've had some affinity for Justice Kagan. I don't mind saying that. And the reason for it is when I read her decisions, they make so much sense. All right, I just want to say good afternoon to everyone. Let's go ahead and set forth our appearances. We'll start first with the plaintiffs, then we'll move to the witness.
Good afternoon, Your Honor. Will Kemp for plaintiffs.
Good afternoon, Your Honor. Teddy Parker for plaintiff.
Good afternoon, Your Honor. Robert Eglet. Excuse me. Good afternoon, Your Honor. Eric Pepperman for plaintiffs.
Brianna Switzler for plaintiffs. Erica Esposito for plaintiffs.
Good afternoon, Your Honor. Michael Esposito on behalf of the defendants.
All right, and do we have anyone on Zoom that wants to set forth their appearance? Okay. All right, once again, I just want to say good afternoon. Let's go ahead and get started. Where should we go first?
I told Mr. Esposito whatever he wanted to do since this is his first appearance.
So gracious, so gracious. Your Honor, where would you like to start? We got to get through all four of them. We have one motion from the plaintiffs, 3 from our side.
Right, I guess let's go for a new trial. How about that? Go to the meat of it.
So, let's see here. Yeah. You know, Your Honor, I was having a quick conversation with Counselor Kemp right before Your Honor took the bench. And I think the way I would like to approach this is not to rehash every motion in limine that was argued before this court before trial. Most of the issues that were raised in this particular motion are directly related to conduct or jury's response to conduct that we had, I would say, warned the court about during the pretrial process. A lot of that came to fruition. And for the reasons set forth in the moving papers, we do believe that a new trial is warranted. One case, though, in particular, that I think needs to draw the court's attention, and this is going to be viable for both this motion and the other motion on punitive damages, is the implications of the United Healthcare Insurance Company v. Fremont case. That's a decision that came down in 2025. After this, this court did not have the benefit of that guidance from the Supreme Court during the pretrial motion process or during any of the prior trials for real water. And what this case has clearly demonstrated is that when we're looking at the level of punitive damages or the amount of punitive damages that can be awarded, a ratio of 1-to-1 in a situation where there is negligent conduct as opposed to, and I believe the phrase they use is trickery and deceit, but something more intentional, is about as much as the Constitution can allegedly stand. The Nevada Supreme Court in United Healthcare went so far as to say that even if there was a statutory cap in place, a 3-to-1 is still unconstitutional under those particular sets of circumstances. So what you see in the briefing quite a bit, Your Honor, is we're asking to draw to this court's attention the actual evidence in the case that demonstrates that there may have been a finding of negligence. There may have been actions that could have been interpreted as grossly negligent, depending on the court's point of view. But at the end of the day,
Well, I think the findings were strict products liability defects pursuant to the restatement of clause 2A. It's slightly different than a finding of negligence. We can all agree. But
that is to the extent we're talking about the analysis conducted in United Healthcare and the analysis as to the actions of a party, Your Honor, it's somewhat beside the point. What the Supreme Court is saying is that it's not the result that drives the ratio for punitive damages, it's the conduct of the party that was held liable for that result. And in this particular case, according to United Healthcare, if somebody's acting negligently, no matter how severe the result is, the constitutional guardrails require a dramatically lower ratio between the front tying the compensatory damages to the punitives.
well,
And
can't we
so-
say this for the record? Simple negligence and or gross negligence is not enough. Right? You have to meet the mandate of NRS 42.001 et al. Right?
Which is why we're not working off of negligence as a term of art, Your Honor, or as a claim. What we're talking about here is if we look at it from a weighing of the severity, right? And so the question becomes whether or not the severity of the action of the conduct or of the basis for finding liability leads more towards, again, not a term of art, but simple negligence versus something that is considered to be intentional, deceitful, purposeful trickery meant to harm.
Okay, what,
People.
you're going down a road I want to talk about. And here's my point.
Sure.
And I thought that it was very telling during testimony. And I can't remember all the players by name, but I remember what was testified to. And apparently, at some point, the individual that was, I guess, allegedly involved with product quality and control goes to Blaine. Was it Blaine? Is that? He goes to Blaine and he says, look, we got a problem here. We got to take this off the market. We got to stop producing it because there's all these complaints. And he didn't get the type of response you would hopefully anticipate. The response was give them a new case of water. That's my recollection. It's been 6 months or so ago, but it was something like that. And I'm quite sure Plaintiffs' Counsel will point me in the right direction with a little particularity as far as what was uttered, because that was the testimony, right? Something like that. And so the reason why I say that, I mean, I'm very familiar with punitive damages, the countrywide. If you take a look at the countrywide, I think this is countrywide. I don't want to cite the incorrect footnote, but specifically at the footnote, they talked about in one of the footnotes, it has to be something more than gross negligence. I get that, right? We're talking about a statutory requirement. And my point is this. It appeared to me that we had sufficient evidence to support punitive damages.
Well, and let's talk about that for a second, Your Honor. Well, 2 points, I guess. The first being that the testimony you're talking about that happened in 2020, in late 2020, doesn't fit in on the timeline in a manner that would support the ultimate finding that I think the court is leaning towards, right? If there has been.
And for the record, I want to say this, I don't have any ultimate findings. That was made by the jury, right? I just have to make a determination as to whether or not there's the motion meets the requirement for a new trial.
Sure. And Your Honor, I would advocate to the court that something that happens at the very back end of the timeline is not indicative of the conduct of the party for the years prior. And obviously, there's several things that we can get into if the court is inclined to do so that are briefed in great detail. Everything from allowing complaints that go all the way back to 2012 that have absolutely no substantive indication that they have anything to do with hydrazine into the case in the first place, to arguing that these demonstrate that some sort of procedural safeguard would have prevented the injuries that happened to the plaintiffs in this case when there's no evidence to back it up. We have references to inflammatory commentary about babies and puppies. And there's all of these things that add up, Your Honor. So if we're talking strictly about the basis for new trial in general, no, we're not focused on one thing here. What I'm trying to get to specifically with this argument is simply that under United Healthcare, the court's not inclined to grant a new trial. And the court's inclined to reduce the overall punitive damages award. Then the court should take the Nevada Supreme Court's guidance and examine the conduct of the plaintiffs over the course of the correct course of the timeline, right? And that means not looking at innuendo or argument of counsel that a bottling issue in 2014 or 15, for example, or a strange smell in one of the bottles is somehow tied to hydrazine in the water when that has never been proven.
But don't you think that odors from drinking water, I think there was testimony regarding red slime, and a lot of different things like that would put a product manufacturer on notice. And you know what, maybe we need to take a closer look at this. Maybe we need to do a little testing. Maybe we need to do a little bit of this or that. I mean, but go ahead, I'm listening to you though.
No, and fair enough, Your Honor. I would argue to the court, again, just advocating for the record, that we have run a danger in this case from the very beginning, and I've seen this in the trial testimony and other cases of being far too generalized. Saying, well, we should have been on notice. Well, notice of what? Products have issues of varying degrees and varying causes and varying problems all the time. The trick that has been utilized in this case to sway the jury's emotions is to point at everything all together and say, well, look, there was a problem, or they should have been on notice, or there was something they should have done differently. And it even bleeds into the punitive damages phase where we stop talking about real water whatsoever and we start talking about the entire bottled water industry generally. And beyond that, Coca-Cola is a manufacturer in these billion-dollar companies. It's this ambiguity, it's this broadness of argument that has created so many problems. And this is the reason that the defendants have been advocating for the imposition of certain fail-safes, certain guardrails throughout the course of the trial in the first place. And Your Honor, I think as far as this is concerned, what Real Water would be asking this court to do in reaching a decision, if the court is not inclined to grant a new trial and is inclined to reduce the punitive damages award, and this speaks to both motions, is enter findings that are consistent with the court's direction in United Healthcare and the 10th Circuit case that underlies it, right? At the very least, establish the law that says this is how the Nevada Supreme Court has interpreted State Farm. This is how the Nevada Supreme Court is applying Phillips Morris. This is how the Nevada Supreme Court is applying this law. And it's not allowing for an award constitutionally that is of the severity and of the size that the plaintiffs are asking for in this case, or the plaintiff, or even the one plaintiffs proposed to reduce it to. And so as far as this argument goes, Your Honor, that's the one side of the coin, is the United Healthcare issue. The other side of this coin, and I'm going to go back to this briefly, but again, Your Honor heard me ad nauseum arguing this during the motion limiting process. Gidney, Allen v. Anderson, there's a variety of case law out there that should not have allowed this court to ignore the bankruptcy and the financial condition of Real Water in reaching its decisions. And what the court saw throughout trial
So
is,
there, are we going to the second phase as it relates to the punitive damages? What are we going to do?
yeah, what we're talking about now is the fact that there was no legitimate purpose to sustain a punitive damages award against Real Water in the first place. So we're still on this motion. Realistically speaking, Your Honor, there are, I see it as very clear case law that says that, one, you don't separate deterrence from punishment. These are not disjunctive things that you consider when evaluating whether or not a punitive damages award can be entered. They have to be considered together. And what happens when you don't? We saw it at trial. All of a sudden,
But I think
plaintiffs are making.
I considered both as a factor because, they kind of go hand in hand. You punish, right? That's one thing. And then you want to prevent future conduct.
Well, and Your Honor, the problem here is that the jury wasn't allowed to
Yes.
consider that.
That's the deterrence.
The jury was never allowed to consider the fact that Real Water was not operational, that they were bankrupt. The jury was never allowed to see Real Water's financial condition. The jury was not allowed to see a wealth of information, and yet at the same time, we're giving the jury unsupported speculative testimony from Mark Rich about market caps of billion-dollar companies. And at the end of the day, this came out in a variety of ways. It wasn't just showing how obscenely absurd the punitive damages award was, but coming to positions where plaintiffs' counsel is making comments like, well, there's nobody here from Real Water, so they must not find this case to be very important. Well, there's nobody here from Real Water, Your Honor, because they're in bankruptcy and their agent is currently a plaintiff against Real Water. There are all of these very bizarre and frankly, I think purposefully constructed problems that were leveraged in trial that arose out of the fact that the court determined that somehow Real Water's bankruptcy, Real Water's financial condition couldn't be considered in either phase of the trial. And Gidney is very clear, right, that these factors are considered in tandem. So, Your Honor, like I said, I've argued this quite a bit before the court, the same thing with the complaints.
And I'm sorry, no, I don't want you to, I don't want to cut you off. I mean, that's an issue Supreme Court's gonna have to grapple with. I mean, I said that at the time, remember, I said, because I had no guidance on that. But go ahead. I don't want-
No, you're fine, Your Honor. And honestly, that's why I'm trying to just kind of glaze over the top of this, because I do understand the court's position.
Actually, and I always push back on this, I have never have a position. I might make a point, but I'm not an advocate, so
Fair
I
enough.
don't have a position.
One day I'm gonna learn to use the right wording, Your Honor, I promise. Anyhow, so Your Honor, as far as this motion for new trial, or to amend the judgment and remitter, the details are all laid out before the court, and I'm well familiar with how well read the court is coming into these hearings, so I'm not going to belabor the point, but we would ask that the court reach a decision that is reflective of the Nevada Supreme Court's recent guidance in United Healthcare, and that the court take another look at the arguments that are raised in case law like Gidney, because now that we've seen the ultimate result of what happens at trial when this information is not allowed in, and the prejudice that it has, and the way that it inflames the jury's sensibilities, I think it's become a more poignant issue. And so with that, I'll rest, Your Honor, unless you have any questions on these issues.
Not at this time, sir.
Perfect.
Thank you.
Yeah,
Mr. Kemp.
Your Honor, I'll be brief, as well. I hope that. United Healthcare, that was a commercial case, but of interest. The court said, quote, "The Supreme Court found a punitive award issued on a ratio of 526 to 1 was substantial, but when considering the rule of potential future harm, did not defy constitutional sensibilities." So this is our Supreme Court saying that in some cases, 526 to 1 is appropriate. In that case, they didn't think it was appropriate. That was a commercial fraud case, Your Honor. The allegation in that case was Fremont Medical Center, which used to be down in Fremont Street. I don't know if they're still down there. Was somehow cheated by United Healthcare, which didn't surprise me when I heard that. And on some sort of billing dispute, and despite the fact that that was a contractual arrangement, there was a punitive award entered. But that was a contractual case. It was commercial fraud. It was a one-off. There's no physical harm. It involved one plaintiff. It wasn't an epidemic. The conduct was commercial fraud, which is not good. But I mean, compare that to the conduct we had in this case. You mentioned Mr. Randolph, who got on his knees and twice and begged Blaine Jones to issue a recall because all his relatives were sick, and he heard about other people getting sick, and they didn't do a recall.
And I didn't get the names correct, but I remember the.
Right, and that was back in September, early October of 2020. And a lot of the plaintiffs got sick after that point in time, so a recall would have prevented all the injury. But that was just one element of bad conduct. They did investigate customer complaints. They had a institutional procedure where they give free water instead of investigating. Customer complaints got referred to the sales
I
department.
don't want to cut you off, but this reminds me that all those complaints and prior events would come under, I guess, the category of red flags.
The red flags, Your Honor. Some of them were redder than others, but they were red flags. And the real problem is we had 3 different quality assurance directors testify. Well, they were called quality assurance directors. They really weren't quality assurance directors. None of them had seen the complaints. They're supposed to be the directors of quality assurance. They hadn't seen the complaints. And then Patty Converse, the very first one, was pretty upfront. She admitted she had no training whatsoever, didn't know how to do her job. And that's because she'd been the receptionist for a couple of weeks and they promoted her to quality assurance. And this,
You know what, my impression of her was she was a very nice lady.
yeah, she seemed like, I'd hire her as a receptionist. I don't think I'd hire her to be quality assurance director. And then they had pointed warnings, like the NSF report we entered from 2018. That specifically said that there's no one qualified in this company to make safe drinking water. I mean, what more of a warning could you ask for? And in that same report, they flunked, I think, 18 out of 18 applicable quality assurance points, and they got a 3.6% on that section out of 100. I mean, these aren't just red flags, these are pointed warnings from the industry auditor. And we made a lot of the fact that at the very beginning, when they came on production, they had this bizarre manufacturing process where they'd electrify distilled water that had some minerals in it for 2 different 8-hour shifts. And despite this very bizarre manufacturing process, they didn't do standard ingredient testing. It would have cost $100. Then they got all the customer complaints. They didn't do any ingredient testing on that after any of those. None done at any time until the CDC came in and did it after the fact, and immediately found the hydrazine. Council mentions Gidney, which is the Nevada probate case, which we point out why it's not applicable. We have cribbed. Actually, the Gallagher opposing brief's been written before we filed this. So we did some more research and we cribbed a bunch of cases from Mississippi and elsewhere where they address specific situations where people were bankrupt and they allowed punitive awards anyway because it was for deterrence. And if you take a look at our opposition to the motion to alter amend pages 18 through 20, those cases are cited. Starting with the Mississippi Supreme Court in Magnolia, that's on the bottom of 18. We continue on to Waldman, which is another Mississippi Court of Appeals case that applies the first one. And then we talk about a Kansas case that is emphasizing deterrence. And they're all emphasizing deterrence because that is the rationale that applies in this particular instance, since there can be no punishment. You know, real water filed bankruptcy, you can't punish them. And so that's why the issue here is really, if someone files bankruptcy, does that abrogate deterrence? And all the court decisions we've cited say no. They haven't cited any that say yes. They try to misconstrue. I don't think they did in this brief, but in the Supreme Court brief, they try to misconstrue Sumer Corporation versus Greens Fund, which definitely doesn't say that. But in any event, Your Honor, for deterrence, you have to give the jury some sort of handle. They admitted that you have to give them some kind of guidance. And in this case, we gave them the bottled water industry's profits, and that was an appropriate thing to do for deterrence, because that is who is being deterred. Okay, that is the industry that is being deterred. And hopefully it's my fond hope that there will be some deterrence out of that manufacturers in the future will at least test their product before they bring it on market, or they'll hire real quality assurance people instead of promoting the receptionists. So hopefully there is some deterrence, but that's going to be developed in the future.
You know, what's important to point out, because I do remember the factors. And for example, when it comes to the ultimate determination as to whether punitive damages as an award should be reduced, one of the factors we consider would be annihilation. However, we can't consider that right now because the company's bankrupt, right?
Right, and under the annihilation case, Ace Trucking, the burden of proof's on them. Burden of proof on them is to prove annihilation. They annihilated themselves, and they admitted that in the briefing. They called themselves a dead party. So, you know, you can't wave around these truly outdated, because the last financials they had were from 2019. Those are 6 years old now. So they want to show 6-year-old financials that have nothing to do with the current state of the business operations because they're in bankruptcy, and use those as some sort of shield against a big punitive award. That's really what they wanted to do, Your Honor. And that's just not appropriate, because the punishment prong is you limit the punishment so you don't cripple the company. You know, there's no way to cripple someone who's bankrupt because they're already bankrupt. And that's what those cases that I cited about 18 through 20 of our opposition. So, you know, we could have said, let's push it. You know, let's award the full amount of punitive damages instead of reducing them. But we're taking the same position we took in the past, that should be reduced to a single digit 9.991 ratio. Even though we have this.
And that's what I've ruled in the past in other cases.
Yeah, that's what you ruled in the other cases, even though
And even going back before then,
right.
in other cases.
You know, I could say, well, United Healthcare says 526 to 1. I could argue for the higher number. I could do that, but you know, it's not going to make any difference to the ultimate outcome of the case, Your Honor. So we're more than happy with the 9.99 to 1. And
that comports with State Farm.
yeah, that can, well, and again, State Farm approved a 4 to 1. And that was another commercial case. They were commercial insurance policyholders who allegedly cheated throughout the country. And, so we have all these commercial cases, which are lower ratios. We don't have any guidance from the Supreme Court suggesting that there's going to be a 1-to-1 on a personal injury case involving an epidemic. And that's issued squarely teed up in Gallagher. That's one of the issues on appeal, because on appeal, they make the same argument that was made today, that it should be 1-to-1 or 4-to-1, or, let's pick a number out of the air as opposed to what the jury did. But that issue is squarely teed up in Gallagher, Your Honor. But for that reason, we think the two motions should be denied, with the exception that we've agreed to reduce the ratio to 9.99.
Mr. Parker.
I think Mr. Kemp handled it.
Okay, Mr. Eglet, anything else? All right, this one overlooking, fine gentlemen.
Well, I disagree, Your Honor, but that's. Yeah, and I'm just gonna read a couple of things into the record, because the comment, well, that's how I ruled last time. Again, United Healthcare wasn't here last time. And here's a few things United Healthcare is asking this court to consider as of 2025. First and foremost, when compensatory damages are already substantial, a ratio of 1-to-1 may be the most the Constitution will permit. United Healthcare is saying you have to look at the size of the compensatory damages, the amount. It's not a question just of ratio. We have 95 million in compensatory damages here, Your Honor. We have a bankrupt company. Now, the other issue that's raised United Healthcare, and this is.
Here's my next question for that.
Sure.
And they say those are issues that have to be considered. What do you do in scenarios where, and understand this is what's very important. We have a case involving the most, other than oxygen, one of the primary necessities for life, and that's water, H2O. And I remember the testimony, and a lot of it's my recollection, the plaintiffs gravitated towards real water because they thought this product was safe to drink, right? And yeah, I mean, that was some of the testimony. And it was an alkaline product and those types of things. But my question is this, when we're talking about product that's going to be consumed by the public, babies, young people, adults, senior citizens, and the like, don't you think that when it comes to products of that nature, when it comes to deterrence plays a very, very important factor in this respect? Because when you go buy a bottle of water, don't you expect that the bottle of water will be pure, right? That it won't contain hydrazine in it, and those types of things. And isn't that a different case than other types of cases? Because at the end of the day, it seems to me that the deterrence when it comes to products being consumed by the citizens of this country, we should make sure that they're unadulterated. Right?
Your Honor, one, I do agree with the court on the consumer expectations.
Right.
One would not expect to have hydrazine in water. I don't think anybody's ever argued to the contrary. At least I hope nobody's ever argued to the contrary. More to the point, though, I think what we're doing is we're looking at issues that aren't part of the analysis for this particular ruling. The fact remains that, one, whether or not actual bottled water, and by the way, there is a marked difference between alkaline water and, say, municipal water or spring water, right? And in this particular case, we have the added issue of the fact that we had a proprietary process that was creating the water, and it's that proprietary process that caused the issue, according to their expert. Dr. Najm says it was this proprietary titanium tube process. They brought the tubes out at trial. They walked them over to the jury. This is a process that nobody has ever used, that nobody's using, and that nobody ever will use again. Nobody has the rights to do this. So when we're talking about deterrence, there's no justifiable purpose for this punitive awards when What we're trying to do is deter a process from being used that can't and won't be used. It's a self-defeating argument.
Well, here's my question as far as the proprietary process is concerned. Number one, it's a process that nobody ever used before,
Correct.
you know, the titanium tubing from Russia. And then it's my recollection, the gentleman, and he was a very nice man, old man, but they developed this process from a testing perspective. I guess he would drink it until he got sick. Wasn't that something like that?
I think he would drink it till he got alcosis or whatever that particular chemical reaction is when you have too much alkaline water, if I remember
Yes.
correctly. I'm sure plaintiff's counsel knows this quite a bit better than I do, but again, Your Honor, that has absolutely nothing to do with how Coca-Cola, for example, or Nestle or anyone else creates their alkaline water.
Oh, but here's the point. If you have a new process in place, you need to test that new process.
And they did, and we were not allowed to introduce that
Test the
evidence.
process. They didn't. I mean, they could have, what was the name of the test they could have run? The broad spectrum, what was it?
Non-targeted GCMS testing, Your Honor.
It's like a broad spectrum. You see what's in it. What was it, $100?
100 to 200.
Well, and Your Honor, now we're getting back to the actual merits of the motions, because the problem is the court didn't allow evidence on the testing that was being done. The court determined that we were not allowed to show what testing was required under certain regulations. The court determined that there was no evidence that was allowed to be permitted to show the actual good faith efforts that Real Water was making. And there's nothing in the record or even that was presented by Catherine Hutt that shows that there's an obligation by any new product, anybody that creates or invents a new product, to use this specific non-targeted GCMS testing. So what we're doing is this is a straw man.
I can tell you what it is. If you could, I would think it doesn't matter what the product is. If you have a new process in place and you're gonna sell a consumable product to consumers in this country, you better test that product or you're gonna live with the results, right? I mean, that's really something very important. And it doesn't matter whether there's automobiles, it doesn't matter whether there's crashworthiness, it doesn't matter whether there's airlines, it doesn't matter whatever the product might be. These products are tested. And here's the thing about it. There's so many standards out there, ANSI standards, ASTM standards, and they're all there in place. And my point is this, they went and did something that was unique, never been done before, didn't properly test the product. And lo and behold, they got to live with the results.
And Your Honor, that would have been appropriate had the trial been, if the jury had been able to hear about the other testing that had been done, and they were able to make an informed decision as about whether or not this one non-required test was the one that absolutely should have been done or the product never should have made it to market, because that's the assumption that was allowed to be given to the jury that has no underlying evidentiary basis. There's nothing that says that that non-targeted GCMS testing is the one that had to be done or should have been done, or even that it was something that any product manufacturer of the scale of Real Water would even known to have done in the first place, going through the testing agencies.
Then they shouldn't sell water with new production processes in place by having the water run through titanium tubes from Russia. I mean, that's really pretty tough there.
And I hear what the court is saying, Your Honor. So I'm going to move on.
That's really unique. It really is. And
so, Your Honor, getting back to,
but especially for consumable product, But go ahead, sir.
you're fine, Your Honor. I just want to make sure that I'm getting each of these points made. If we go to 127 United Healthcare, it says additionally, the amount of punitive damages appears to be based in part on trial evidence about United's relationship with its insured and United's conduct during litigation rather than only United's conduct aimed at team health. We've provided the court with a wealth of trial testimony.
What do they mean by that? United's relationship with its insured.
I would rather direct the court's attention to United's conduct during litigation.
Okay.
That's what I have underlined, Your Honor. That is where I think the primary point here needs to be made. Again, when Real Water is barred from explaining to the jury why they don't have a corporate representative sitting at the table, when Real Water is barred from explaining to the jury why certain offers of judgment weren't accepted or why they were promoting certain defenses. I misspoke with the offers of judgment. Yeah, no,
I'm about to jump over the table.
as it was coming out. As it was coming out.
All right, here we go.
Yeah. Sorry, like that?
All right.
Maria, help me out.
Continue on, sir.
Yeah. I can say other things that'll get them jumping up and down, but no, legitimately though, Your Honor, the fact remains that it's not just why there isn't somebody at the table, but we had an entire presentation to the jury about the frivolous nature of even being here in the first place. And that's
You
all,
say frivolous nature of being here in the first place, what do you mean by that?
I believe they referred to the frivolous defenses when they knew that they were at fault because the court has already decided causation, the court has already decided liability, and why are we even here? And the fact remains that if the jury is being prejudiced against the party based on their conduct during litigation, their trial strategy, everything else, United Healthcare says that has to be weighed in reducing an overall punitive award because that's improper.
Okay, well, we can talk about that. Let's dig it a little bit deeper. Maybe if from the very outset of the litigation, the defense in this case stood up and said, you know what, Judge? In our answer, we're accepting responsibility for the unfortunate event. Then that might be a different scenario, right? But that didn't happen in this case, did it?
So Your Honor's question is why didn't,
You talk about conduct during litigation. It's my understanding, during litigation, the defendants in this case fought hook, line, and sinker every step of the way. Versus, maybe that might be compelling if, when the answer was filed, we admit the product was defective, unreasonably dangerous pursuant to the restatement of torts 402A. You know, that's a slightly different scenario. That's conduct during litigation. Maybe I could consider. They admitted liability, you know, and
Your Honor,
from
the
the
jury
very
found it
outset.
compelling. The
What?
jury gave Garcia 0. The jury found these defenses compelling, and at the very least in good faith.
What did they find compelling? What was the
There's a
award?
significant causation issue, I mean, and a damages issue with Garcias in the first place. And again, that's something different. But the fact is, a party's decision to defend itself, especially with the specter of massive amounts of punitive damages hanging over his head, right, is improper. That's an improper basis. You can't hold that against the party and then say, well, punitive damages are warranted. That's exactly what United Healthcare is saying, is that is the exact example of something this court should not allow a jury to base their award on. And it needs to be a basis for reducing the damages.
And
And
what
so,
did it, I mean, I'm trying to figure out what did the jury base the award on vis-a-vis conduct during litigation? Because they thought it was based upon the evidence produced at the time of trial.
Your Honor, we've presented the court with a wide variety of testimony and advocacy from counsel that shows differently. And so, again, I don't want to get into
that's okay.
rereading the motion here, but the fact is, if the court is going to render a decision on this respectfully, I think potentially even a minute order addressing these various considerations in United Healthcare would be helpful because this is new for the court. This is not something that the court had last time real water was tried. This is not something the court had when we were arguing motions in limine. And the Nevada Supreme Court is very, very clear that these are things that warrant a significant reduction, potentially down to a 1-to-1 ratio on punitive damages. So again, Your Honor, I mean, the only other thing I was going to bring to the court's attention is that Gidney has been wildly misrepresented. Gidney is a receivership case, but the point of Gidney has nothing to do with the underlying nature of the case. Gidney and Allen, which was the probate case that I believe opposing counsel intended to reference, both speak to the fact that when there's nobody to punish, it defeats the purpose of punitive damages. And I understand the court's inclination to say, well, deterrence here is so important. This is a, H2O. This is something everybody drinks. But again, the position that Real Water has taken, and I think this is supported by a variety of the case law, including very clearly in Gidney, is that you can't separate out deterrence and punishment and say, we're only going to look at one.
Well, what do you do when punishment is no longer available?
You let the jury know that their award is not going to punish this particular defendant. That is a consideration that they have to take into account. That's the reason why the financial condition of the defendant is required if there is a defendant with a financial condition.
And see, I kind of look at it that in this regard, which is slightly different, and I think this is because what's missing in the component. Ultimately, the total amount of punitive damage is based upon the US Constitution. I'm required to reduce it. Right? And in this case, in the past, I've gone about 10-to-1. That's what I've done, right? And so they don't get the whole punitive damage award. And the question is does it 10-to-1 offend due process, you know? And this is really and truly what's different about that case. Because as you mentioned before, we're talking about a products liability case, right? And just as important too, coupled with that is the consumer expectation. And the Nevada Supreme Court has adopted a restatement of torts second as it pertains to the consumer expectation test. And so I look at it this way, and ultimately the Supreme Court is going to have to look at this, but I want to make sure they understand what my thoughts are when I made this decision, because that's why this is different. This is a consumer product. This is baseline of what every living entity on this planet needs. They need H2O. And under the circumstances of this case, the H2O was not pure water. It was actually a poison. And that's what it comes down to. It contained hydrazine. And hydrazine, my understanding, is rocket fuel. We had a lot of testimony after that. And so what do? Right? And I think that's important. And I see that as a clear distinction. Maybe the Supreme Court will agree with me, maybe they won't. But this is a slightly different case. And if any type of case you're going to have deterrence in, it has to be cases involving products like water. Right? It has to be. And if they feel it's 1-to-1 is sufficient in this case, one thing I will say, I'm a good soldier. I'll go with whatever they say. But if you understand what I mean, and it's important to be a good soldier and follow the mandate of the Supreme Court, whether you agree or disagree. But that's the difference I see. I really do.
Well, and so, Your Honor, with that in mind, I'm gonna uphold the promise I made to Counselor Kemp and to the court as to the second motion. These are all the same underlying issues, right? We're talking about the argument that it's plain error to allow the complaints in, that there was prejudicial argument that was meant to inflame the sympathies of the jury.
Yeah.
There's an argument.
And I went through a pretty good analysis as to the complaints, right? I had like a 6-step.
Yes,
What
you
a
did, Your Honor.
6-point? Was it more than that, Mr. President? Okay,
Yes.
I spent a lot of time on that. On that, and I forget the name of the latter case, but that's the case I based. Krause, yes, Krause, and the fact that, remember in Krause, and this is important, he didn't even know if they hit his knee on the lever. Right? They didn't even know that, but the Supreme Court said it can come in. That, and I don't mind saying that was the pivotal case for me as far as my decision making is concerned. Krause.
Well, and to that note, Your Honor, obviously, real water defendants disagree with the way that the substantially similar test is applied.
That's okay.
Krause is applied. So I will leave it at that.
That's okay. I get it. We wouldn't be here if you agreed.
Correct. One thing I do want to address, and counsel, I don't know who's on the second motion. Eric is. But I believe we have in here, we've agreed to 120-day stay of execution from the hearing date. Is that still in force?
And
in place?
if you've agreed to that, I agree.
Okay.
So you don't have to argue that. I can't remember any time in probably 20 years, believe it or not, coming up, that I've rejected the stipulation of penalty. I never will do it.
So, and then the only other remaining thing, Your Honor, is how the court wants to approach the requested offset from the settling defendants.
And we can go to that next. This is what I'm going to do. Now, I just want to make sure the motions we have here, we have, it looks to be AffinityLifestyles.com, DBA Real Water, LLC, and Real Water Inc.'s motion for neutral or the alternative to alter amended judgment and for Medicare and request to stay. Well, we have 120 days stay in place, right, based upon stipulation. Regarding the motion, I'm going to deny it. Regarding, I've gone 10-to-1. Mr. Kemp suggesting 9.9-to-1. Alex, say that again?
9.99.
9.99.
Just so I can say with a straight face, the Supreme Court, it's a single digit.
I accept that.
Okay.
I've done more. That's what it'll be.
Okay. Thank you, Your Honor. And then as far as the offset goes, moving on to the second motion, and this will be very brief. We've presented the court with the reasons why trying to speculatively gauge how much of a settlement is compensatory versus punitive is a non-starter. The entirety of the settlement amounts need to be included in the offset. There's a wealth of law included in the moving papers that backs that up. And again, I'm not going to get into all of the other issues that are raised in the motion. We've just discussed those at length, but we would ask for all the relief contained in the moving papers, including the full valuation on the offset.
Thank you, sir. All you. Mr. Pepperman?
Thank you, Your Honor.
All right.
So, Your Honor, I just want to make sure that we have some clarity here on the record because we're talking about two separate motions. The first was the motion to alter or amend the punitive damages award, which I understand that motion was denied in part and granted in part, granted to the extent that the punitive award is reduced to a ratio of 9.99 to 1.
Correct.
Okay. The second motion is the motion for new trial and to alter or amend judgment. And that motion tees up the, new trial based on the admission of customer complaints based on alleged improper conduct and the offset issue. So my understanding for that is it's denied to the extent of a new trial based on the customer complaints issue or the attorney misconduct issue, and the only issue is the offset.
Correct.
Okay.
And I don't mind saying this for the record. The reason why I spent time as it pertains to the prior events issue and the Krause case and prepared the 6 point or whatever point I came up with as far as what factors should be considered is because I knew it was going to go up on appeal. And I wanted to give the Supreme Court something to consider. And just as important too, they can't say my decision was just arbitrary and capricious. And there was a factual and there was a legal basis for my decision making. And that's why I did that, because I took my time on that one. I remember spending a lot of time on that.
Yes, Your Honor. And as to the alleged attorney misconduct, as counsel said, it was well briefed. We agree that for purposes of preparing the order, is it fair to say that it's denied for the reasons stated in the
There's
opposition?
no attorney.
Okay, so just the narrow issue left on this one is the offset. Your Honor, this is the 5th time we've had this issue addressed, the 3rd time by you specifically. We'd ask that you rule consistent that as you did in the prior Brown et al. Matter and Gallagher et al. Matter, which is to say that based on Lindbergh v. J.E. Johns v. Lindbergh, which is the seminal case on this, it very clearly states that when there are joint tortfeasors responsible for the same injury, they're entitled to a credit for those damages. They are not entitled to a credit for settling exposure to damages beyond those joint damages, which are individual to the settling defendant, such as treble or punitive damages. And so what our argument has consistently been based on is there are settlements and for some of these plaintiffs, those settlements settled exposure to both actual damages for the joint injury or for the same injury and for individual damages for such as punitive damages. And we think that the proper offset applied is based on the ratio of punitive to compensatory damages awarded against real water. And so they would get an offset for the same amount as the ratio of compensatory to punitive damages that you just ruled on. So 9.99 to 1.
Understand. All right, anything else, sir?
That's it, Your Honor. Thank you.
Your Honor, I don't know if we have any changes in controlling law or anything else to add to the conversation, so we're gonna rest on the moving papers based on your initial argument.
Thank you, sir. And Mr. Pepperman, last word, anything you want to?
Mr. Kemp just reminded me that it is the burden to show that apportionment is on the defendants challenging the offset. So just for the record, I would make that my statement. Thank you.
All right. And it's gonna be my decision. I don't see any, and I don't see the need to deviate from my prior decisions as far as this is concerned. And as far as the offset, it'll be the same as the ruling I just made, 9.99 to 1. Got that, Mr. Pepperman?
I do, Your Honor. Thank you.
I've got one more, Your Honor.
Yes, sir.
It's the motion
Making
to,
pretty good progress.
Ryan, Your Honor, this is the motion to retax.
Oh, yeah.
Your Honor, I'd like to go through every single receipt, every single line item, and have a discussion, if that's okay with the court.
Sure, you know, I always enjoy your discussions. No problem. I really do.
Short version, Your Honor, to the extent the motion points out that there's a lack of documentation, obviously that burden's on them. If they haven't met the burden, they don't get paid. Few things that stand out. I'm shocked to see the amount of money that is attempting to be charged for Westlaw. The law is pretty clear that electronic research can't be charged. Says we hold computer research expenses are not recoverable costs, Bergman v. Boyce, 109 Nevada 670. It goes back to 93. Beyond that, Your Honor, I think the big issue that I took, I know I argued this before you already, but in particular, and this is representative, is Dr. Singh. There's a lot of money here for a doctor that was brought into trial to present argument on causation after causation had already been established. Now, we raised this point before trial. Opposing counsel argued, no, there's other things he's going to say. It was very ambiguous. Once again, it was just this broad sweeping, trust us, there's something good there, and there wasn't. The entirety of the testimony was about causation, which had already been established. So I'm not going to get into each expert and each witness and each set of documentation, Your Honor, but I would ask that the court not approve their expenses in full, sit down with each of the individual sets of documentation and determine what they are actually entitled to and what they are not, and simply strike the portions of it that are contrary to law or that were deemed or obviously unnecessary after the trial was completed. Unless you have any questions, Your Honor.
Not at this time, sir. Thank you.
Good afternoon, Your Honor. I also don't want to go through the minutia of necessarily going through every single cost or anything like that. I just think it's important to point out that counsel's very generalized arguments are that there's not enough proof or documentation regarding to most of the cost. We submitted over 1,000 pages of documents and proof. A lot of those are individual invoices detailing name, date, when it was, the type of thing that it was. It's on our printing. It says motions, exhibits, everything that it goes down to. For the experts, it goes through each individual thing. I found it very interesting that counsel mentioned that the Westlaw costs were not appropriate and expressly forbidden, citing to the 1993 case. That case was actually before the recent amendments to NRS 18. And so now NRS 18.00517 actually expressly says that you're allowed cost for, quote, expenses for computerized services for legal research, unquote. So Westlaw is no longer forbidden. It's actually expressly in the plain text of Rule 18. So that's something to point out. As far as Dr. Singh, and we've spent a lot of time in our opposition to this motion to retax on the experts because that's the primary portion. In our opposition, we detailed exactly why Dr. Singh and the other experts that we had were necessary and met the Fraser standards and the factors. And we believe that as this court witnessed all of the experts pretty much on display as it was, that they were all necessary, reasonable, and they were actually incurred as demonstrated by the over 1,000 pages of documentation that we submitted as far as our memo of cost detailing each invoice, each service, all those things. Unless the court has a specific particular questions or anything like that, I'll submit the rest on the briefing as far as that we well and over established that they were necessarily and reasonable and actually incurred.
Thank you, ma'am.
Thank you.
Nothing further, Alan.
And I just want to make a couple comments, because I will review in more detail the fees and cost requests. But I want to place that on the record, I think it's very important, because I think the Supreme Court overlooks the job and role of the trial court when it comes to assessing fees and costs. And the reason why I say that is this, and I do spend some time reading some of our US Supreme Court decisions. And over time, I've had some affinity for Justice Kagan. I'm saying that. And the reason for it is when I read her decisions, they make so much sense. And just as important too, you can tell she was a litigator, right? And when it comes to this specific issue I'm grappling with right now, I always go back and think about the Goodyear Iron Rubber Company case versus Hager, which is a 2017 published decision by our US Supreme Court. And the reason why I do it is she has such great language in the case. And I sometimes think I feel our Supreme Court overlooks sometimes how difficult of a task we have as trial judges, and when lawyers put down their time and the estimates and so on and so on. What I'm going to do is this, I'm gonna go back and look at it, but she has some thoughts. And this comes out of her decision, and she says, quote, "This but-for causation standard generally demands that a district court assess and allocate specific litigation expenses, yet still allow it to exercise discretion and judgment. The court's fundamental job is to determine whether a given legal fee, say for taking a deposition or drafting a motion, would or not have been incurred absence of the sanctioned conduct." But this is where the rubber really meets the road as far as I'm concerned. And she cites another case, the Fox case. And she says, quote, "But as we stressed in Fox, trial courts undertaking that task need not, and indeed should not, become green eye shade accountants," period, close quote. Because it makes perfect sense. It really does. Or whatever the contemporary equivalent is. The essential goal is shifting fees is to do rough justice, not achieve auditing perfection. And I don't mind telling you, I'm not an accountant. I mean, I was a business major. I specifically, after taking the first two accounting courses, I realized this is something I did not want to do. Right? And she's right. She says the essential goal is to shifting fees is to do rough justice, not to achieve auditing perfection. Accordingly, a district court may take into account its overall sense of the suit and may estimate in calculating and allocating an attorney's time, period, close quote. It makes perfect sense, right? It really and truly does. Because,
What's the citation? Just because you have the case up.
I'll give it to you. Yeah.
Just since
Well, I think they probably know that I come back to this case sometimes. They've been in front of me enough. But for my, and I don't mind saying it, every time this issue comes up regarding attorney's fees and costs, I always read this in the record just in case someone or the Supreme Court wants to know what some of my thoughts are, because I do feel they kind of overlook it, you know. And the reason why I do it too, remember, we have that party presentation case that says the trial court's not limited to just what the parties put in front of them if they know there might be other applicable law out there. And it makes perfect sense. It really does. And the only reason I do that is this, because I know our Supreme Court will look at it. And if you look at the Barasini case and some of those cases, it's almost like you're charged with being an accountant. And I'm not. All right, I'm gonna try to do the best I can and follow the law. And I'm gonna go through it for you, sir.
Oh, we can ask Your Honor. Thank you.
All right.
Your Honor.
Is there anything left?
No, Your Honor.
Oh, yeah, yeah, and I brought my binder for a reason.
All right.
What do you need, Mr. Parker?
I did, Your Honor, but I will need the podium at least on the initial presentation of the motion. I prefer just to allow the court to listen to Mr. Esposito, and I'll reserve my time for rebuttal.
All right,
The briefs are great in this on this motion, Your Honor.
sure. So which one is it we're at now, Mr. Parker?
It is plaintiff
Okay.
motion for attorney's fees, costs, and interest under NRCP 68 and NRS 17.117.
I understand. Oh, I'm with you now. I did.
1.2 billion, Your Honor. It's kind of a staggering demand in my book. And again, I'm not going to get into the weeds on all this, but I don't know that allowing an attorney's fees award that is what 13 times the compensatory damages is legitimate in any way, shape, or form. There were obvious concerns when the decision started coming down, allowing for contingency fee-based fee awards to be occurred in the first place.
Remember, I didn't make that decision.
I'm not blaming the court, Your Honor.
I mean, that decision was made by Justice Parker, right? Wasn't that his decision?
Was it Parker?
Yes, I think so. Maybe I'm wrong. We can
Trying-
take a look. I think it was him.
Trying to remember myself, Your Honor.
Which case?
What was the, I'm trying to remember the name of the decision.
Capriati?
Was it Capriati?
Is that what you're talking about?
I
Yeah, I
can't
got it.
remember. Either way.
I'm almost positive it was Justice Parker.
Yeah.
Right?
So, Your Honor, realistically, the crux of this entire opposition, and again, trying to keep this nice and short. The court is allowed to make its own determination on what's reasonable for attorney's fees. Frankly, any reliance on the offers of judgment in the first place is misplaced. When you have a bankruptcy court saying this is arguably a violation of the automatic stay, and then you're making offers of judgment that exceed insurance policy maximums, when you know that there's a tender to an interpleader, and you know that there's absolutely no way that a party in good faith could respond the way that you are now saying that they should have responded, it's gamesmanship at its finest. And so to the extent that this is the way that they want to go to ask for attorney's fees, I don't know that they've justified their ask. And to the extent that any fees are awarded, 1.2 billion is obscene.
Yeah, here's my question. How do I make the determination as to whether that's appropriate or not? Because Justice Parker said it's fine. You ask for a percentage. And I remember a lot of things. I don't mind saying. I remember when Mr. Eglet was trying the endoscopy case and he made a fee request for a percentage. At the time, it wasn't provided for under the law, right? It just wasn't. So I went with the per diem or whatever the hourly. It was still a lot of money. But my point is this.
It's a lodestar.
Yeah, lodestar. There you go. Thank you. Thank you, Mr. Eglet. But my point is this, and it's really this simple. That was then, which is now. We have the Nevada Supreme Court case that said it's perfectly appropriate to give a percentage, right?
And Your Honor, I think if for starters, looking at compensatories instead of the full amount, let's start there. Let's talk about the fact that we can do it based on market rate of attorney hours. The fact that something is allowable does not mean that it's justifiable in a particular context. The courts have been very clear that there are other ways that this can be calculated. And I think that's all been presented in the opposition. So all again, trying not to go too far into the weeds on this, but I would ask that the court go back and look at the alternatives to a $1.2 billion attorney's fee award and make a determination as to what makes sense, if anything. And honestly, I would ask the court pay special attention to the manner in which offers of judgment were served and what the implications of the timing and the amounts were. And Your Honor, again, I understand that, Mr. Parker was gracious enough to let me get up and say my piece before he responds, but I would like to reserve a little bit of time in the off chance that Mr. Parker says something that I feel I need to address. So I'll just leave it at that.
And that's fine, sir.
I know, Your Honor. Thank you.
We have to make records. Mr. Parker, sir.
Good afternoon, Your Honor. Teddy Parker on behalf of the plaintiffs. Your Honor, you alluded to the Capriati case, which is a 2021 case, and certainly that case came after the endoscopy case.
Oh, absolutely. Absolutely.
That Mr. Eglet and Mr. Kemp were involved in. But, Capriati has set the stage. and 40% has been approved since then by more than just yourself.
Understand?
You approved it in the Gallagher case. Judge Kishner approved it in the Hunwartson case. Judge Hardy approved it in the Wren case. Your Honor, it's been 3 judges, 4 verdicts in this case, and all judges have come back with the same decision. This was a case that started out with a water bottle and unknown etiology in terms of what was causing children to go be taken by Life for Life to the primary children's hospital in Utah. It took a brave lawyer to even pick this case up in the first place. Because at first, the FDA didn't know, the CDC didn't know, and the Southern Nevada Health District did not know what was going on. And the families of these children would not have been financially able to pay for all the costs, all the time that it took to develop this case. Your Honor, we had 20 experts because we needed 20 experts. This was not a car accident case where perhaps you'd have video camera from a street sign somewhere near a street light or ring camera or somewhere catching a rear end accident case where liability is pretty easy to determine. This is a very complex case. And I say that because these are some of the factors that go into Beatty and Brunzell. And so I'm sure the court's following along. But that's what happened here. And this case was started in 2021. And we tried, when I say this case, the investigation related to this case, the first complaint was filed in 2021. We didn't see the inside of this trial until this year. And between that time, we've had X number of depositions, X number of expert reports, X number of depositions of experts. Just in this case alone, we had over 60 motions in limine. We had motions for summary judgment. This case took a tremendous amount of work. And, it was a privilege for me to be involved, but I would venture to say that very few cases involve Mr. Kemp and Mr. Eglet, where you have that amount of, I would say, plaintiff power to represent families like this. 2 of the plaintiffs suffered autoimmune hepatitis because of the trigger related to hydrazine being in real water. Those cases alone were very difficult. I think they were a first impression where hydrazine has been the trigger of an autoimmune disease, one of which is going to cost Mr. Eglet's client, Ms. King, the rest of her life getting IV, IG injections. My client will have to live with that as well. Mr. Kemp represented the other 11 clients in this. So when Mr. Esposito gets up and says 1.2 billion is a lot, I wonder if he consider what's the value of what these plaintiffs went through. Is any amount of money too much? When we have, by way of example, Ms. King subjected perhaps to the rest of her life getting injections that may include some form of STD. We don't know. She could get HIV, she could get some other illness because she's getting blood transfusions. So I struggle when I hear Mr. Esposito's argument, because not only do we have the 13 plaintiffs that are part of this case, Your Honor, but you were part of the first case where we had a death. And we have other cases now with deaths involved. You're aware of the fact that we have cases with liver transplants. This is not a case to be confused with the recent United case, which was a contract type claim. In fact, it boiled down to the Supreme Court agreeing that it was an unjust enrichment claim, strictly dealing with money and repayment of emergency medical services. That's not what we have here. So, Your Honor, looking at NRS 17.117 and NRCP 68, we did offers of judgments on all of these plaintiffs. And one of the things that was pointed out in the reply brief, which I thought was very good, I don't know if Bree put that reply brief together or not. But it mentioned that the defendants suggested to the jury that they give more money to these plaintiffs than the offers of judgment. That's an indication of just how ridiculous their refusal not to pay the offers of judgments were. Your Honor, one of the other things that I would point out, and I don't attribute this to Mr. Esposito because this expert was retained prior to Mr. Esposito and his firm being involved. But Dr. Goldsmith retained him in 2023. He gave an opinion in 2023 that real water containing hydrazine caused the outbreak of the acute liver failures. But they knew that information before they decided to try this case. And Your Honor, Goldsmith's testimony has been available to Real Water for 2 years before this trial went forward. And we attached that to the briefing, Your Honor. I'll mention for the record, Your Honor, under NRCP 68 and NRS 17.117, fees should be awarded. We exceeded our offers of judgment and all of those, Your Honor. In terms of the 40%, we referenced in the briefing the Schutte case, which is a 2005 case, 121 Nevada 837. And it indicates in that case, Your Honor, the Supreme Court said that the judge's discretion should be tempered only by reason and fairness. And I think that goes a little bit along with the U.S. Supreme Court case you were discussing relative to costs. We also reference, Your Honor, the Tarkanian case, which is a 1994 case, which talked about and allowed for both the lodestar approach as well as a contingency fee approach. We also reference, Your Honor, Nevada Rule of Professional Conduct 1.5C that allows for contingency fee agreements, which we had in this case. And then finally, Your Honor, as we mentioned earlier, we referenced the Capriati case, which is 2021, 137 Nevada 675. In terms of the factors, Your Honor, for awarding fees, based upon the offer of judgment, that's the Beatty case, Beatty versus Thomas, 99 Nevada 579, is a 1983 case. The factors are the good faith nature of the offer, the reasonableness of the offer, was the rejection unreasonable, and were the fees sought reasonable, Your Honor. And then, of course, the factors under Brunzell to determine the reasonableness of the fees, the quality of the advocates, which I don't believe in the opposition Mr. Esposito is objecting to, Your Honor. I don't believe there was any. I think he conceded that point. The character of the work is what I was speaking of earlier. The complexity of this case, the novelty of this case, Your Honor. There had never been, to our knowledge, a water product that contained hydrazine. And certainly there was a significant amount of work done to determine how this process created hydrazine. In fact, the defendants never offered a single expert who could figure it out themselves. We hired, and I don't know how Mr. Kemp found this person, but we ultimately hired the #1 hydrazine expert in the country. Had written articles on hydrazine, and that's who was presented, Dr. Najim. So when it comes to the character of the work, Your Honor, the complexity of the work, the difficulty of the work, the intricacy of the issues, certainly this case meets the factor 2 of the Brunzell factors. The work performed, Your Honor, I discussed that at length, how much time it has taken to bring these cases forward, the amount of work, the skill of the lawyers, the time and attention it required. Then the last factor under Brunzell, of course, is the results. Your Honor, out of 5 cases, we've had 3 that have exceeded $1 billion, $3 billion for the third case, over $5.2 billion for the second case, and now virtually 3.1 in this case. The defendants argue that the bankruptcy nature of Real Water for some reason should affect the court's decision, Your Honor. under Beatty, under Brunzell, there's nothing that says consider whether or not the entity is in bankruptcy. There's no factor that addresses that. What I find to be telling or supportive of our position and telling in terms of what the defendant didn't mention is the bankruptcy order itself does not limit how we were to proceed. It didn't say you can go forward except for getting a judgment on punitive damages. That's not included in the bankruptcy order. So I don't believe that's a strong position for the defendants to take. In fact, I don't believe it's supported at all. Your Honor, $1.2 billion, Your Honor, is what we're asking for because it is 40% of the compensatory and the punitive damage amount, Your Honor. And again, it is consistent with the St. Paul Fire Marine case that we cited, which is a 2022 Nevada case. The site is 521 P3rd 418, and which also cited the Allstate versus Miller case, which is 125 Nevada 300, which is a 2009 case, Your Honor. Unless the court has any questions, I believe that covers all of the arguments and hopefully summarizes both the brief, the opposition, and reply, Your Honor.
So,
Thank you.
Esposito, you want to add anything, sir?
You know, Your Honor, I knew that Counselor Parker would say something better than I could, so I appreciate the opportunity to respond. Mr. Parker just talked about the novelty of the case, the value of what the plaintiffs went through, the uniqueness, and I think what's important to note is Mr. Parker also went through how many times this case has been tried. Now, if we're looking at Brunzell, we're looking at Beatty, we're looking at factors like the work actually performed, or whether or not fees sought are reasonable and justified in amount. The inherent problem with asking for the contingency fee arrangement in a unique circumstance like this one is that we're awarding the same work over and over and over and over and over again. I mean, yes, they're here, they're trying the case, but the novelty is worn off. That research has been done. The vast majority of the motions in limine were recycled through each case. The purpose of allowing an award of that size doesn't pencil when you talk about something like this, where you've had a case tried 5 times. So at the end of the day, awarding an amount that, and I'm going back to the papers here, that if $500 an hour would cover 2,400,000 hours of work, or the equivalent of working 24/7 for 274 years, doesn't make sense. And so, Your Honor, with that in mind, I would ask that the court look at this in the aggregate, understand that the point of Brunzell, the point of Beatty would be to award work that is complex at the time it's being done, not complex 5 cases ago. And at the very least, make an adjustment to reflect the purpose of what these statutes and what these rules are meant to award. And that's it, Your Honor. I mean, I could get into anything else the court wants to, but I don't want to belabor the point, considering that I'm already on, reply.
That's okay. And we just wanted to give you that opportunity.
Very much appreciated, Your Honor.
Mr. Parker, you get the last word of thanks.
Mr. Kemp and Ms. Switzler wanted me to make sure I placed on the record the most recent Supreme Court case on this contingency fee award issue. It's dated September 8, 2025, Your Honor. It's the Lewis Bellomo, Bellomo, versus Thunder, Roball, and individual respondent. So that's the name of the case. The case number is 86412, if that helps. Mr. Esposito located.
Sure.
Your Honor, the only other thing I would mention, other than referencing this case, I think it's ironic that Mr. Esposito, I'm sorry. Oh, yeah. Your Honor, the other, before I change seconds, that case, the Supreme Court affirmed a 50% contingency award, not a 40%. So I guess Esponte, you could grant us 50%.
We oppose that too, Your Honor.
We could change the briefing quickly, Your Honor, resubmit. But Your Honor, the one thing that I found ironic is Mr. Esposito, I don't know if he's meaning to trivialize the work that went into trial number 5. But if that's the case, let's say that Mr. Esposito is correct, that this is the 5th go around and it's not novel anymore. But I would think that sword would cut both ways, because if this is the 5th trial, and they've seen 4, or at least read transcripts on the 4 preceding trials, then why did we have a defense that took 3 or 4 lawyers in here defending this trial, this case for the 4 weeks that we were here? A little longer than 4 weeks. Why did we need 60 motions in limine that were so hotly contested? Your Honor, you can't have it both ways. We worked just as hard with case number 5 as we did case number 1. We had different depositions to take because we had 13 different plaintiffs. There's no reason to discount the effort that went into trial number 5 because we were involved in 4 previous cases, Your Honor. And that's how I went into trial.
All right.
Thank you.
I would just point out that this wasn't my 5th trial or 3rd trial or 2nd trial. I had to learn this case from start to finish before I put on. I had my own witnesses in addition to some of the witnesses they has used. So that I don't buy that argument anyway, but it certainly doesn't apply to me.
Thank you, sir. Anyway, I just have a couple of comments and because I guess I've heard more of these than anyone. Is that correct?
That's
right. 3? Yes. And for the record, I don't mind saying this, there was nothing routine about any of these trials. I mean, it just wasn't. And just as important, as I was listening, and I was thinking to myself, and I said a handful would be too generous. There's only a couple of law firms in this jurisdiction that could have handled these cases, and they just happen to be here today. And that's just how it is from a plaintiff's perspective, because it's not just a fact of skill, which plays a tremendous role, case management, which plays a tremendous role. But we can't overlook it. And I don't know if the Supreme Court ever addressed this, but even having the resources to take a case from start to finish and litigate a case of this magnitude. For example, there was a very unique issue here regarding the hydrazine expert. And how did you find him? You know, I'm just sitting here thinking about how complex this case really and truly was, right? And I've heard, and I did see an evolution of how the case was being presented. There's no question about that, but that takes work too, right? You streamline. I'm quite sure the focus grouping was going on and a lot of other complex things. And my point is this, ability and more importantly, resources, doesn't that count too in some way, some form or fashion? Because just looking at the cost that have been incurred, who can do this other than the lawyers that are involved in this case right now today? That's kind of how I look at it. And so I remember going back years and years ago, and when this argument was being made, and I just wanted to make sure I went the route that I felt that our Supreme Court would accept. That's why I did the Lodestar. Today, I'm going to go ahead and award the 40%.
Thank you.
Like I did before. Interestingly, I guess you can do a 50% now. I didn't know that.
Only Mr. Claggett gets 50%. We're only 40%.
That's the other firm that can think of it.
The deal, my fee goes to 50%.
But I mean, this case was exceedingly complex. I mean, for example, what was it? 29 witnesses in 1 week. Was that the number ultimately?
That's right.
How did you do that?
We were moving, Your Honor.
Yes. But anyway,
So it's granted as the interest as well in your cost?
yes.
Thank you.
And what I'm going to do, I'll take a look at the. I won't put on my green shaded accountant's hat, but I'll take a look at the costs
Thank you.
and go through that and issue a minute order on that issue.
Thank you, Your Honor.